Good morning, everybody. For those of you in attendance, what we're going to do is before we start, we're going to have a quick committee meeting. We're going to adjourn, and then we're going to go into the hearing right after that. But with that, we'd like to welcome everybody to the Commerce Committee. Katie, will you please take the roll?
Yes. Chairman Lawrence,
Here.
Barger,
Designation.
Marla Brown,
Designation.
Diorsi,
Designation.
Gatos,
Designation.
Gleim, Representative Gleim. No? Okay. Labs,
By designation, and she is also on the Teams call.
okay. Marcel,
Designation.
Olsummer,
Designation.
Durin,
Designation.
Schaefer,
Designation.
Torzik. Present. Chairman Conklin,
Here.
Bellman,
Designation.
Eamon Brown,
Designation.
Carroll,
Designation.
DePita Freites, Cephas,
Designation.
Harris,
Designation.
Kenyatta,
Designation.
Monroe,
Designation.
Nelson,
Designation.
Parker,
Designation.
Ellie,
Designation.
Rab,
Designation.
Sanchez.
Designation.
Okay, we have a quorum.
Thank you. With that, we have one piece of business to do today. The chair would like to call up House Bill 2175, printers number 2831, 2175. Oh, sorry. I'm easily confused. Please don't put any shiny objects in front of my face today, or I will follow them. Indira, please read a summary of the bill.
Thank you, Chairman, and good morning, everyone. House Bill 2175, sponsored by Representative Schusterman, prohibits suppliers of AI chatbots from selling or sharing consumer information with a third party and would prohibit the advertisement of specific products or services to a consumer unless there is a clear and conspicuous disclosure.
Thank you. With that, the committee would like to report the bill as recommended to referral to the House Commerce Committee, Protection Technology. Oh, the House Consumer Protection Committee. That's why I don't read. I try not to, or use reading glasses because then I look old. Is there any questions on the referral? Please bail me out, Chairman, as soon as you can.
Thank you, Mr. Chairman. Good morning to everyone. I certainly have no objection to the re-referral and to Consumer Protection Committee, and all Republicans will be in the affirmative. Thank you, Mr. Chairman.
Without objection, I'd like the record to show that it passes unanimously. Are there any other business brought before we adjourn? With that, we're adjourned. Good morning, everybody. We would like to start the hearing on, I don't have the bill in front of me, on 2120. I just want to let everybody know that as we do the meeting, each individual will be sworn in. This is a hearing, and I want you all to understand that this is also being videotaped as well. So when you come up, each group, I will swear each group in separately rather than doing the whole group at once in case somebody goes in between. With that, could you just give us a quick overview, and then I'll have Representative Venkat come up, and then I'll...
So good morning, everyone, and thank you all for attending. As the chairman stated, today we will be discussing House Bill 2120, sponsored by Representatives Venkat, Twardzik, and Powell. The agenda has been disseminated to everyone, so you guys know what's going on. Water bottles for the testifiers have been made available on the table, along with table tents with your names. Thank you.
With that, Chairman Lawrence, do you have any words of guidance before we begin?
Thank you, Mr. Chairman. I appreciate the opportunity to be here today to review this legislation and this hearing on this issue. I appreciate the work that Representatives Venkat and Representative Twardzik, and I believe Representative Powell as well, have put into this issue, and certainly looking forward to the testimony here today. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. If we could have Representative Venkat come up. Representative, if you could please stand for a second, raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Thank you, sir. Please begin.
Chair Conklin, Chair Lawrence, members of the House Commerce Committee, thank you for bringing up House Bill 2120 for discussion today. I also want to thank my constituent, Wendy Gilch, who is here and from whom you will be hearing later today, and who educated me on the issue of shared appreciation agreements, as well as my partners on this legislation, Representative Twardzik and Powell. To summarize my written testimony, it has been established for decades that for any home-secured financial instrument, we expect rigorous transparency, consumer protection, and prohibitions against predatory lending practices. That's why Act 6 has been in place since 1974, and this is not unique to Pennsylvania. It's in all states and throughout the country. The fact of the matter is shared appreciation agreements are fundamentally the same as mortgages. That to any prudent person who looks at them, they would say there are closing costs, appraisals, liens, an expectation of return on capital, and the possibility of foreclosure. Every jurisdiction that has looked at this and every court that has looked at this has said that substantively there is no difference between a shared appreciation agreement and a mortgage. However, here in Pennsylvania, because these are unregulated, we have a very dangerous situation. According to Community Legal Services, who will be testifying later today, there are at least 1,000 of these contracts that are in place in Pennsylvania, and likely many more because they are unregulated and untracked. The nature of these instruments should raise a great deal of concern with all of us in the General Assembly. They are largely marketed to individuals who are in desperate financial straits. They involve discounts on appraisals that essentially eliminates the downside for those who originate these instruments. And in fact, the industry, the coalition, who you'll be hearing from shortly, on their website equates that discounting process to differences in interest rate risk. And so they are essentially acknowledging the analogy to mortgages in their own statements on their website in this regard. There is a federal court case that was filed last month in New Jersey, a class action lawsuit against HomeTap, one of the originators of these instruments, related to the consumer protection disclosures on these instruments. The return on capital that is expected far exceeds our anti-usury statutes. It can be 20% or more on an annual basis. And the industry has stated point blank that they do not believe that they should have to perform an ability to repay assessment, which is a fundamental requirement for other home-secured financial instruments and a necessary reform that came about after the housing crisis in 2008. Finally, these instruments are securitized. They're marketed into the financial world. And very similar to mortgage-based securities, the risk is there from this situation. House Bill 2120 was drafted in consultation with the Department of Banking and the Office of Attorney General, two agencies that are led by very different political affiliations and have indicated, just like other states have done, that shared appreciation agreements should be classified similar to mortgages. It should be noted that Act 6, into which House Bill 2120 would be amended, specifically includes language that allows the adaptation of regulations to the specific nature of products that come under Act 6. So the contention from industry that this would be a de facto ban if they had to meet the requirements of other home secured financial instruments can be taken up with the regulators as opposed to setting up a whole new statutory framework, which is what the industry is advocating for. Lastly, it should be noted that other states have taken the exact same approach, and despite the contention from the industry, it has not resulted in a ban or a failure to market their product in those jurisdictions. And so House Bill 2120 is not a ban. I anticipated at this moment to close my testimony to you, Chair Conklin and Chair Lawrence, but events from the last week require me to bring another matter to your attention that need to be considered in this hearing. A week ago, I received a call from a Pennsylvanian who has signed a shared appreciation agreement. She reached out to me to explain how this financial transaction has been devastating to her. It has led to a huge amount of debt, huge financial costs, and that she assumed that they were already regulated similar to mortgages, but was not the case. But what she said next was even more troubling. She said that she heard about this hearing from an email from Point, one of the companies that is part of the coalition and from whom you will be hearing today, soliciting testimonials from individuals who have these products. And in that email solicitation, they offered a financial inducement for their testimony, specifically a $50 Amazon gift card. I will say that in my time in the legislature, I have never seen anything like this. And I've spoken with senior members of the legislature who've said they have not seen it either. Frankly, this is an outrageous corruption of our legislative deliberative process. We expect transparent, unbiased testimonials that come before us. And if you look at this email, and I've given it to staff to distribute to the committee members, and if you look at the testimonials that are in your packet, it is obvious that this email solicitation is what has led to the testimonials that were presented to you without any disclosure that it was as a result of a financial inducement to do so. This raises two questions that I think the committee needs to ask the industry in their testimony today. First, what does it say about your credibility before us as legislators that you would resort to such tactics and, more importantly, not disclose it? Secondly, what does it say about the nature of your product that you needed to provide financial inducements in order to provide us with positive testimonials here? My sincere hope from the testimony today is that we will all be informed on the nature of shared appreciation agreements and that the result will be that we move forward with House Bill 2120. Thank you very much, Chair Conklin and Chair Lawrence.
Well, thank you, Representative Venkat. Or will you stay for a few questions? And when we're completed, could you stay till the end in case there are more questions?
Absolutely.
Any questions? Representative Torzik?
Thank you, Mr. Chairman. Doctor, thank you for bringing this to our attention. It is pretty shocking that we're doing pay for play here, and it's probably not the best way to get results. And thank you for sharing this information. It'll be enlightening to find out how they defend it.
I will leave copies of the email here on the desk also so that testifiers, should they wish to look at it, can do so as well.
Any other questions for the testifier? Chairman Lawrence? Just real fast, could I just ask you just quick questions? Mm-hmm. You know, you had talked about the New Jersey relating this lawsuit or wherever it may be
yeah.
related, misleading homeowners.
Mm-hmm.
Could you just dwell a little bit more into that
Sure.
and what brought it about, if you know?
Sure. So it came to my attention from my constituent Wendy Gilch, so please ask her about it as well. But it was a class action lawsuit that was filed in the district court in New Jersey against HomeTap, saying that they were not meeting the provisions of the Truth in Lending Federal Act and in their dissemination of this product, and saying that as a result, consumers have been damaged and asking for class action certification in order to seek damages as a result.
Thank you. And just one more follow-up, and we may have more. Do you know if the coalition may have paid the Urban Institute for producing any of the reports?
I don't know the answer to that, but I think it is a question that is worth asking, given that they submitted the report from the Urban Institute as part of their testimonial packet, and that the question, given that they've obviously engaged in pay-for-play, as my colleague Representative Twardzik stated, it's worth asking whether other testimony that they have submitted falls into that category as well.
Thank you, Representative. If there are no other questions, we'll bring you up. And if the first panel could come forward, that would be Jim Riccatelli, Lee Kapman, Jesse Silverman, Matthew Windsor, and Cliff Andrews. Please stay standing when you come up, and then after you're seated, I would ask each one of you to introduce yourself so we have a face with a name. See, when you have over-efficient staff and a chairman that, again, gets sidetracked, they have to keep you on track constantly. With that, would you all please raise your right hand? Do you all swear and affirm that the testimony that you are about to give is true and correct to the best of your knowledge, information, and belief? Thank you. Please be seated, and if you could, go down so we could put a name with each face then. Thank you.
My name is Matthew Windsor, Deputy General Counsel at Point Digital Finance.
Jesse Silverman, General Counsel at HomeTap and Board Member of CHEP.
Jim Riccatelli, CEO of Unlock Technologies and a Board Member of CHEP.
Cliff Andrews, President of the Coalition for Home Equity Partnership.
Thank you all very much. Mr. Chairman, anything to say before we begin again? With that, the floor is yours, gentlemen.
I'll go ahead and start. Can you all hear me okay?
If you keep your mouth close to the microphone, these, yeah.
Great. Okay. Can you hear me?
Yes.
Perfect. All right. My name is Cliff Andrews. I'm the President of the Coalition for Home Equity Partnership, also known as CHEP. And I would like to thank Chairman Conklin and Chairman Lawrence for holding this hearing. And we thank all committee members for your time today and appreciate the opportunity to testify. Founded in 2024, our members on this panel, HomeTap, Point, and Unlock. CHEP is a national nonprofit association representing companies that offer homeowners responsible, flexible ways to access their equity. Significantly, as part of our mission, CHEP has dedicated substantial amount of time focused on crafting industry model legislation, a model disclosure, and advocating for regulations to protect consumers. I would like to underscore that CHEP fully supports the regulation of shared appreciation agreements in Pennsylvania, and indeed nationwide. We believe that a clear regulatory framework is good for homeowners, good for the companies we represent, and good for the broader market. However, HB 2120 in its current form is unworkable, and if passed, it would function as a de facto ban on shared appreciation agreements in Pennsylvania. My CHEP members will elaborate further. The Shared Appreciation Agreement was created to address a real and growing gap in the financial landscape, one that is actually felt by your constituents. Home prices in Pennsylvania have climbed 69% since 2021, while hourly wages rose only 25% over the same period. The income needed to afford a median price Pennsylvania home now stands around $85,000, a threshold that exceeds the state median household income of around $80,000. There are high property taxes and growing high home insurance premiums. Credit card debt has risen 11% since 2021. and Pennsylvania homeowners carry total household debt averaging around $84,620. These figures reflect households managing tangible financial pressures. Many of them have significant home equity, but they find themselves increasingly unable to access that wealth. Shared appreciation agreements were built to address precisely these concerns. In fact, a study released last week by the Urban Institute noted the following, quote, shared equity products can be useful for homeowners who cannot get a mortgage loan or who choose not to make a monthly payment, but want to take advantage of the wealth stored in their homes, end quote. This study validates, and you'll hear more about it, that shared appreciation agreements are providing real, meaningful financial benefits to a broad array of homeowners, including those who qualify for traditional forms of finance like mortgage loans and HELOCs, but are concerned about taking on another monthly payment obligation, and those who simply do not qualify for a mortgage loan, such as seniors living on retirement income. This committee has received numerous written letters from homeowners across the state who found themselves in financial situations where traditional financing was not an option. Those individual letters reflect unique stories, real stories of homeowners and how they use these agreements. And you know, I would encourage you all to look at those individual stories. In closing, I should note too, in those stories, what you'll note, the top use cases for these products is to retire high-interest credit card debt, to fund home renovations, improvements, start a small business, cover college tuition, address medical emergencies, and navigate life transitions such as divorce. In closing, CHEP fully supports robust regulation to protect homeowners. However, such regulation must be properly crafted. We respectfully urge the committee to decline to advance HB 2120 in its current form and instead work with CHEP and other stakeholders to develop tailored legislation to address the unique structure of shared appreciation agreements that protects homeowners while providing a pathway to compliance for our members to remain a viable financial choice for Pennsylvanians. We look forward to continuing working with you. Thank you.
Thank you. Next.
Yes, Chairman Conklin, Chairman Lawrence, members of the House Commerce Committee, thank you for the opportunity to testify. Oh, okay. Is that better? Yeah. Okay. Thank you. My name is Matt Windsor. I am Deputy General Counsel at Point Digital Finance, and I'm testifying as a part of CHEP and as a board member of CHEP. We support strong, enforceable consumer protections for home equity investments. And we have supported regulation for our products in many other states, including Illinois, Washington, and Connecticut. But we oppose HB 2120 because, as drafted, it would effectively eliminate a home equity financing options that many Pennsylvania residents already find valuable. I want to focus on something you'll hear from supporters today, that industry self-regulation has failed, and that Act 6 is the appropriate framework for these products. Let me be direct. CHEP is not asking for self-regulation. We are asking for regulation. Licensing and supervision, standardized disclosures, reasonable caps, and enforcement that allows the contract, that follows the contract, even if it is assigned in the secondary market through securitizations. This is the exact opposite of how companies with different products, like MV Realty, have operated. Supporters argue that the General Assembly should be wary of industry writing its own statutory requirements, and we agree with that caution. But the policy question is not whether there should be rules, it's whether HB 2120 establishes the right rules for this product. Everyone here testifying today agrees that Pennsylvania should learn from bad actors, including MV Realty. But the right response is not to misclassify a different product, it is to effectively regulate shared equity agreements through clear marketing rules, transparent disclosures, and meaningful enforcement. CHEP members have also adopted voluntary protections such as third-party counseling requirements, rescission periods, and periodic statements, steps we support codifying and making enforceable. The Loan Interest and Protection Law is an important and time-tested set of protections for mortgage lending in Pennsylvania. Homeowners deserve strong safeguards whenever their homes are involved. But HB 2120 does not tailor Act 6 to a new product. It simply changes the definition of residential mortgage to include shared appreciation agreements, pulling these contracts into a loan framework built around interest rates, amortization, and periodic payments. Home equity investments don't work that way. There is no stated interest rate and no required monthly payment. The homeowners receive cash up front, and the subsequent repayment is based on sharing an agreed upon percentage of the home's future value. If you force mortgage-style disclosures into that structure, you risk producing disclosures that are inaccurate, or worse, misleading, because they imply a payment and pricing structure that does not exist. The same mismatch shows up with the state's ability to repay requirements. Pennsylvania's existing underwriting standard focuses on whether a borrower can make periodic payments on a fully amortized schedule. Shared appreciation agreements have no monthly payment. So an income-driven ability to repay requirement would systematically exclude equity-rich, income-modest homeowners, including retirees on fixed incomes, even though their equity is the primary source of repayment. Pennsylvania already recognizes this discrepancy. In June 2020, the Governor's Office of General Counsel, on behalf of the Pennsylvania Department of Banking and Securities, issued a formal letter concluding that Act 6 did not apply to shared appreciation agreements because they did not meet the definition of a loan under state Supreme Court precedent. To our knowledge, that guidance has not been withdrawn, and the industry has operated on a reasonable reliance on it. HB 2120 would overturn that settled understanding without replacing it with a workable, product-appropriate framework. So when we say that this bill would operate as a de facto ban, we're not being rhetorical. We're describing the compliance reality. Supporters also emphasize Act 6 usury cap, citing numbers like 6 to 7% as a critical protection. But Pennsylvania already distinguishes between first lien and subordinate lien home secure mortgage products. Under the Mortgage Licensing Act, secondary mortgage loans may carry interest rates of up to 1.85% per month, which is roughly 22% a year. Over 85% of our agreements are subordinate to a first mortgage. So a workable framework needs to start from the Commonwealth's subordinate lien rules, not a first lien cap. Finally, please keep the homeowner experience at the center of these hearings. These are families solving real problems without refinancing out of a low first mortgage rate or taking on monthly payments that they cannot manage. CHEP respectfully asks you to vote no on HB 2120 as written and instead work with us, consumer advocates, the Department of Banking, and the AG's office on product-specific regulation that delivers real consumer protection without eliminating an option some Pennsylvania homeowners genuinely need. Thank you.
And good morning.
Hey.
Chair Conklin, Chair Lawrence, members of the committee, thanks for your time today. My name is Jim Riccitelli. I'm the CEO of Unlock Technologies, one of the founding members of CHEP. I'm also a board member of CHEP. We are opposed to HB 2120, but make no mistake, we want to be regulated in Pennsylvania. We're ready to work with this committee to accomplish that goal. Last week, the Urban Institute published the most comprehensive study of shared equity products ever conducted. This committee now has access to more hard evidence on this product than any legislature has ever had. Please read that report. Urban analyzed 54,000 agreements originated by CHEP members. The research was led by Lori Goodman, one of the most widely respected housing finance researchers in the country. This is a data-driven analysis of how these products work, who uses them, what they cost, why they're incompatible with mortgage regulations, and how to properly regulate them. The research directly contradicts what you'll hear from those who oppose our products. Opponents will tell you that our customers are people with no other options. Our customers tell a very different story. Many of our customers are homeowners who looked at mortgage refis and HELOCs and decided they weren't the right fit or their applications were denied. Some had low credit scores and difficulties managing debt. Some had strong credit and could have chosen a loan but didn't want monthly payments. Some were self-employed and couldn't document steady income. Some were retirees who weren't willing to refinance a low-rate mortgage. The common thread is not necessarily financial distress. It's a preference for flexibility and a recognition that monthly payment-based products are not the only responsible way to access home equity. Homeowners needing cash today typically avoid refis because they want to keep their low rate, so they often turn to a HELOC. HELOC rates can range from 7 to 14%. Minimum credit score is typically 640, and underwriting is income-based, so many people don't qualify. Urban notes that 36% of HELOC applications were denied in 2024 nationwide. For many that do qualify, adding another monthly payment is a showstopper. We provide an attractive alternative. No need to refi and lose your low interest rate, no additional monthly payment. Shared equity is not a product for people without choices. It's a product that, for some, is a better choice. The homeowners who provided written testimony to this committee confirm that. Penny Myers, a widow from York, didn't want to refinance because she had a low rate and monthly payments on a second mortgage were too high. Bruce Weaver in Fogelsville wanted to access his equity without a monthly payment that would strain his retirement budget. Sophia Newen in Harrisburg had excellent credit but recently started a business and couldn't document her income. These are homeowners who chose the option that best fit their circumstances, not necessarily because they had no alternative, but because our product was better for them. Opponents will also tell you that we deliberately target vulnerable homeowners and that we invest only where we expect outsized appreciation. These allegations are baseless. The Urban Institute studied shared equity users and found that ages, incomes, home values, and equity levels are comparable to homeowners who use traditional mortgage products to extract equity. Our customers are not a more vulnerable population. They are the same population, choosing a different product because it better fits them. The Urban study, and also a University of Washington study, looked for evidence that shared equity providers target vulnerable populations or high appreciation markets. Both studies concluded that the industry does not do those things. Research shows that we're not concentrating investments in markets where greater price appreciation is expected. If we targeted those areas, you would see geographic clustering. You don't. No evidence of predatory targeting. Opponents have cited no study, analysis, or data set that says otherwise. 63% of our customers use proceeds to pay down expensive debt. 21% make home repairs or improvements. Others fund a business, cover tuition expenses, or supplement income. These are the same uses you see with traditional home equity products. The difference is the structure of our products, not the population being served. Opponents argue that our products are extremely expensive compared to mortgage loans. They compare the cost of a shared equity agreement to a first lien mortgage rate, but that's not the right benchmark. We're typically in second lien position. The Pennsylvania legislature long ago recognized that second lien products are much riskier for lenders and provided a different cost cap for them, 1.85% monthly or 22% annually. That's the more relevant benchmark. Note that CHEP members have always capped cost, typically at 20%. Most of our customers use our product to pay down debt. Our cost over 10 years is typically about 11%, and it's capped at 20%. For many, credit card rates are 25% or more, so our product is much less expensive. Urban's conclusion is clearly stated, and I quote, "The return to investors on shared equity products, and thus the cost to the homeowner, is often significantly lower than the interest rate on credit card or personal loan debt. So using shared equity products can be a beneficial economic move for many homeowners." End quote. Note that these cost comparisons largely ignore one of our product's core benefits. Homeowners receive tremendous value from shared equity products because they require no monthly payments, while loans do. That additional value is not captured in a numerical comparison, but it's very meaningful. Most importantly, financial products are priced based on risk. We have much less certainty of investment return versus a loan. Loans earn a profit and get some of the principal back every month, which reduces the lender's risk over time. Our investors receive no payments until the homeowner decides to sell or buy out the agreement. Much riskier, and our risk increases over time. To quote the Urban Institute again, "Shared equity products are relatively risky investments when compared with mortgage loans," end quote. Our opponents want to place us under a first lien usury limit, currently about 6 or 7%. Honestly, that's simply not a sufficient return for investors given the risk. And people have pointed out that this has been done in other states. The limit in other states is nowhere near 6 or 7%, just to bring that out. Also, on the ATR point that came up a little while ago, note that HELOCs are not subject to ATR. First lien, like purchase mortgage loans are, refi loans are, but HELOCs are not. ATR does not apply to every loan product. It applies to the loan products that it makes sense for. So if we had a 6 or 7% cap on our product, that's not going to, we wouldn't have any capital available to serve homeowners. It's not that the product is banned, it's just we wouldn't be able to operate because we couldn't fund the contracts. Our opponents know that would act as a de facto ban. We didn't create the limitations of traditional mortgage loan market. We built something that works where the traditional mortgage market doesn't. Eliminating our product doesn't give homeowners access to cheaper or more flexible financing. It takes away an innovative and important choice that works well for many of them. Thank you.
Thank you. Next. Silverman.
With me for a second. Can you hear me? All right, I might have to encroach on your space here. Thank you, members of the committee. Jesse Silverman, General Counsel of HomeTap. I want to be direct about something, which is the support testimony raised real concerns. Not all of them, but some of them, and a credible response from our side has to acknowledge that honestly. Before I do, though, I want to make an observation about the evidence that this committee will hear today. The support testimony from consumer advocates and legal aid organizations consisted almost entirely of hypothetical harms, statistical projections, and worst-case scenarios. There was very little in the way of documented cases of Pennsylvania homeowners who actually entered into shared appreciation agreement with a CHEP member and were harmed. What this committee did receive, in contrast, were more than a dozen letters from real Pennsylvania homeowners in their own words describing their own experiences, who found these products to be exactly what they needed. We have actual evidence of actual outcomes. Consumer advocates at this point have theories of harm. Both deserve consideration, but they're not equivalent. Now, let me address the specific concerns that were raised because some of them point to real gaps that our model legislation is designed to fill. On the concern that our homeowners haven't settled yet. One argument we anticipate hearing is that the Pennsylvania homeowners who wrote in favor of this product haven't yet reached settlement, that they feel good now, but will experience sticker shock when the balloon comes due. That concern deserves a direct answer. Every CHEP member provides quarterly statements to homeowners throughout the life of their agreement. Those statements show in real dollar terms what the current settlement amount would be if the homeowner chose to exit today. Forgot my glasses as well. This isn't fine print disclosed once at closing and forgotten. It's an ongoing, regular reminder 4 times a year of exactly where the homeowner stands. When Bruce Weaver says he's satisfied with his decision, he's not saying it in ignorance of what he knows. He knows. He received the information every quarter. The quote-unquote settlement shock concern assumes a level of opacity in our members' ongoing consumer relationships that simply does not reflect how these products are actually operated. On disclosure, the concern about disclosure is real. Some advertising for these products has leaned heavily on, quote, no monthly payments and, quote, no interest, without making equally clear what the settlement payment might eventually look like. We agree that needs to change, and our model legislation addresses it directly. But here is what the support testimony did not do. It did not identify specific, concrete deficiencies in CHEP's model disclosure form. It said our disclosures were insufficient. It did not explain what specifically is missing. That matters because CHEP has developed a disclosure form that has received positive initial feedback from regulators in Illinois and Oregon, 2 states that have actively engaged with this product category. That form shows the homeowner the starting value, the investment amount, the projected settlement payment at multiple points in time and multiple scenarios for home appreciation and depreciation, including what they would owe if home values decline. It uses plain language, it requires review before closing, and it gives a homeowner the right of rescission, a period after signing to change their mind without penalty. If consumer advocates have specific objections to that form, we welcome that conversation. But our disclosure is insufficient is not a policy argument. It's an assertion. We're prepared to defend our model against specific objections. Those objections have never been provided. On balloon payments, the support testimony is right that a large lump sum at the end of a 10-year period can be a real shock if the homeowner doesn't see it coming. But as I just noted, our members send quarterly statements showing the current settlement amount throughout the life of the agreement. This is not a product where homeowners are kept in the dark and then surprised. The settlement amount is visible, updated, and communicated on a regular basis. That said, we take the underlying concern seriously. Roberta Radaboff from Carlisle used an HEI to recover financially after a difficult divorce when she was declined for every other option. She's now financially stable and running her own business. But the possibility that a future homeowner in her situation might struggle at maturity is worth addressing in legislation. Our model legislation does that through minimum equity retention requirements. The company's share can never crowd out the homeowner's ability to use sale proceeds to move forward, and through a meaningful right to prepay at any time without penalty. Now, on specific contract terms raised in the support testimony, that testimony pointed to several specific contract provisions that concern consumer advocates, including mandatory arbitration clauses and provisions that some companies have used to conduct proceedings. We are not here to say that every contract term in use across the industry is beyond examination. Some of these concerns may be legitimate, and we're willing to work through them in the context of dedicated legislation. This does not have to be an all-or-nothing affair. What we would ask is that this committee engage with us on these specific provisions in good faith, rather than concluding that the answer is to apply the entirety of Act 6 to a product it was never designed to cover. Targeted fixes for real problems are better policy than a blunt instrument that eliminates the product entirely. The support testimony cited MV Realty, and we've heard it before, as a cautionary tale for why self-regulation fails. But CHEP is not asking for self-regulation. We are asking to be regulated through dedicated legislation with state oversight, enforcement authority, and real accountability. That is the opposite of self-regulation. What is true is that in the absence of a statutory framework, CHEP members did not simply operate without standards. We put consumer protections in place voluntarily, rescission periods so homeowners can change their minds after signing, independent appraisals so the starting home value isn't set by the company alone, cost caps on annualized returns, quarterly statements so homeowners always know that their current settlement amount, enhanced disclosures with scenario-based cost projections, consumer tools and educational resources, and we are now rolling out housing counselors for all CHEP members. Counseling that gives homeowners access to independent, expert guidance before they sign. These are not the practices of an industry trying to avoid accountability. They are the practices of an industry that stepped up in the absence of a regulatory framework and is now asking the legislature to formalize and enhance those standards for everyone. MV Realty was not a shared appreciation agreement. It was a homeowner service contract, a long-term exclusive real estate listing agreement that placed liens on homes in exchange for upfront payments tied to future sales commissions. There is no structural, legal, or commercial similarity between MV Realty and the products CHEP members offer. The UW Evans School 2025 report, which specifically examined large home equity providers, had engaged in whether they had engaged in predatory practices against vulnerable populations, found no evidence of that. The comparison simply doesn't hold, and the committee deserves to know that. What CHEP is asking for is straightforward. Do not advance the bill as written. Instead, direct the Department of Banking and Securities, which already has the statutory authority under Act 6 to tailor regulations to specific product types, to work with all stakeholders to develop dedicated rules. And I can tell you, having spoken with many other of your colleagues in other states, there really is two models that we can look at. We can call this a mortgage and then correct the mortgage requirements for the specific and tailor them for the specific characteristics of this product, or we can create a new product type. And what I think you'll find if you talk to the banking regulators in other states is those that have simply called it a mortgage and then tailored the existing mortgage requirements, if they could go back in time, they would do it differently. They would create a new product type. It is very, very complicated. But we are ready to build it, and we only ask for the chance to do so. Thank you.
Thank you, Mr. Ullman. You win the award for the furthest travel, I believe. But for that, Mr. Kaplan, they've taken all your time.
Yeah, I will defer to my other members and allow.
Oh, no, I just, you have,
I'm,
you have,
no, I'm good.
okay, sorry about that. Thank you. Are there any questions from the members? Chairman Lawrence?
Thank you, Mr. Chairman, and thank you all for being here today. I know some of you had quite a distance to travel, so I appreciate you making time to be here in Harrisburg. I think a number of folks who might be listening to this committee hearing, perhaps online, frankly, may never have heard of a shared appreciation agreement, and certainly you who are here today are experts in the field. For my first question, I'd like one of you to explain to those who are perhaps listening online in plain English in a minute or two what a shared appreciation agreement is. Thank you.
Sure. A shared appreciation agreement from a CHEP member is a new way to access home equity without a traditional mortgage loan. There's a lump sum provided to a homeowner. There's no interest rate. There's no monthly payments. In exchange for the cash, the homeowner will pay the investor a share of their equity in the future when the contract ends. Contracts typically have a term of either 10 or 30 years, and the agreement will end when the homeowner decides to sell their home, or they can buy back the investment essentially based on an appraised value, and a single payment is made to the investor at that time. The payment is typically based on a percentage of the home value or a percentage of the change in home value. There's two different models in use. Is that a sufficient explanation? You want more detail? I can go quite a bit.
I think that's fine.
Okay.
I was asking you the question. So let's just say as a hypothetical, if I have a $500,000 house, and let's just assume for the sake of the argument here that I don't have a mortgage on the house, just for the sake of keeping this hypothetical very simple. What kind of equity could I tap? What kind of payment, let me put it that way, what kind of payment could I receive from any one of the institutions that you represent here?
If you have no existing debt on the property, for my company, the maximum that you could get would be roughly 25%, maybe a little bit more than that, of your home's value.
So in my hypothetical here, that would be $125,000, roughly.
Yeah.
Okay. So then at the end of the term, and you said the term could be 10 years or 30 years, what would I owe you back? I assume I would owe the $125,000 back plus a percentage of the value of the home,
It actually it doesn't work like that. You don't owe the 125 back, okay? So 125,000 represents 25% of the home's value. Now, we apply a multiplier to that. Today's multiplier is 1.8, but for purposes of explanation, let's use a 2.0 multiplier because it just makes the math a little simpler, okay? Although our contract is less expensive than that. But if you apply a 2.0 multiplier, in exchange for a 25% payment, we would get a 50% share of the home's value in the future, right? So when the contract ends, we don't get the 125 back. We just get 50% of whatever the home's value is at that time. Now, to put that in perspective, let's say the contract ends at 10 years, and let's say your house value went up about 4% a year, which is roughly the long-term average in Pennsylvania. I think it's 4.6% over the very long term in Pennsylvania. The payment that we would get, I can't give you the payment dollars, it's just off the top of my head, but I can tell you what it would equate to in terms of an annualized percentage rate. It would be about 11%. So you would receive that 125, you'd make a payment 10 years later, and the net impact of those two payments would be as if the money cost you about 11% per year. Yeah, we cap our cost at 20%. That's to preclude situations where there's extreme home price appreciation, or because we have the multiplier, if the contract ends in the very early years, the cap will prevent us. Like, in other words, let's say you did the contract today, and next month you wanted to end the contract. Your house value didn't change at all, right? We're not going to receive 50% of your home's value. That means we would have doubled our money, instantly. The cap applies in that situation. So we would receive, just the capped payment, right? So if the cap is 20% annually, we would get 1 month's worth of that 20% if you ended the contract a month later, right? So that
So-
might be, yeah, go ahead.
I appreciate that explanation. So again, assuming I receive the 125,000, you're assuming this 2.0 multiplier and average appreciation of the home value of 4% annually. What roughly would I owe you at the end?
I can actually do the math for you if you like. I happen to have. Let's use the exact 4.63%, which is the Pennsylvania average. Okay, on a $500,000 home, if the home value went up 4.63% per year, the home would be worth $786,000 and change at the end of 10 years. So 50% of that would be $393, and let's find out exactly what the annualized cost of that is over 10 years. Excuse me. Okay. That is 12.1%.
So for the initial $125,000 after 10 years, what I would owe upon the end of 10 years
Yes.
is $393,000.
Correct.
Okay.
It's as if you took a way to analogize that would be like this. If you could find a bank, one doesn't exist, that paid 12.1% interest on a savings account, and you put $125,000 in that savings account and let it sit there for 10 years, earning that 12.1%, it would be worth $393 and change at the end.
I understand that.
Yeah.
That's a healthy rate of return. 12% is not bad. I'd like to get 12% on my money, and I'm sure many other people would like to get 12% on their money as well. But that's a healthy rate of return for sure. What
Well,
if
a couple
you said
of
the term could be 10 years or 30 years?
Some companies have a 30-year term. Some companies have a 10-year term.
Okay, so you have. I apologize, I don't know. Do you have 10 or 30
Ours
or
is
both?
10. Ours is 10.
Okay, does anybody here have 30 or no? You do. Okay. So what would the payoff be after 30 years using the same numbers?
Well, it's a little different because the product that Point has operates a little bit differently than ours. There's, like I said, there's
Well,
two
and certainly I'm not going to ask you to explain his product, right? And I don't want to, Mr. Chairman, I realize I'm going quite a long time here, so if you need to cut me off, go right ahead. But I just would roughly like to know.
I'm not a fool. I wouldn't do that.
If I were, I would just like roughly to know, on this hypothetical, which I think is a fairly simple hypothetical, right? If I had a $500,000 home and I received $125,000 payment up front, what I would roughly owe, given you said average home in Pennsylvania increases in value at about 4% a year. And I think there are some places in Pennsylvania where that's not happening, and there are some places in Pennsylvania where it's much more than that. But we'll go with that number. That's your number, and I'm okay with going with that. What I would
number comes from
roughly
the-
owe after 30 years back.
I wouldn't be able to tell you. I don't have a computer to figure that out.
And I understand. What I would like you to provide to myself and to Chairman Conklin,
Yes.
okay, what I would like, and perhaps you could even provide it by the end of the hearing here, I would like to know that if I have a $500,000 house and I were to engage with your organization for $125,000
Yeah.
on a 30-year term, assuming that the house increased in value 4% a year, whatever your number, what was it, 4.6 you said percent?
Yes.
Okay, that annual average rate, right? What I would owe back at the end of 30 years. That's what I would like to know.
We can give you that number, but just to be clear, our product does work differently than the way he described it, so the calculation would be different. So his product is what is called a share to value product, where you pay back a certain percentage of the final value of the home. That's the multiplier. Our product is structured a little differently. So you repay the original investment amount, the 125, plus a percentage of just the appreciation in value.
Okay, so that was where I was going initially with you, but sounds like you don't do that, but you do.
Yes.
Okay, so with you, with Point, at the end of the term, I owe back $125,000. The original $125 that I got, I owe that back to you.
Correct.
Plus a percentage of the appreciation of the house.
Correct.
Okay. And the value, so very key then to that calculation would be what you and I have agreed will be the initial value of the home.
Correct.
How is that determined?
So for our company, we would appraise the home, and then we would take that value and adjust it downward by a certain percentage. It's called a risk adjustment. And so that determines the starting appreciation price, and then that is the price that is used to generate the delta, the appreciation over time.
So what is the percentage that the value of the home would be decreased? Is there a range that you use, or is it a standardized amount?
There is a range over time, but currently the adjustment is, I think, fixed around 25%.
25%.
I
So in
think.
my hypothetical example,
Yeah.
my $500,000 house,
Mhm.
okay, for the purposes of this calculation,
Right.
that's going to be calculated, for the purpose of the calculation, the initial value of the home would even though it's a $500,000 home, would be $375,000. That's correct?
Correct.
So then my house appreciates over time 4.6%, but you're going to calculate and it goes up to let's just say $700,000, right? So
Okay.
it wouldn't be 500 to 700, it would be 375 to 700,
Correct.
which is, I mean, that's a significant amount more to me.
Yes.
Right. Okay. I would like to know. I appreciate that explanation very much. I think it was helpful both to those who are listening to this hearing and to the committee members. And I will wrap this up, Mr. Chairman. I appreciate your indulgence. Thank you. What I would like is if you could provide, and if not today, certainly, follow up to Chairman Conklin and myself. If you could provide that if I were to, again, in my hypothetical situation, have a $500,000 house,
Mhm.
tap in to $125,000, and that's what I get up front. What I owe, you said that you have 10 and 30-year products?
Ours is just 30.
30 years. What do I owe at the end of 30 years? What do I owe back? So it would be the 125 plus the appreciation amount, given the $375,000 valuation of the house down over the whole shooting match. If you could provide that to the committee, I would appreciate it.
Certainly.
Very good. Thank you, sir.
Chair Lawrence,
Yes,
I
please.
think your question highlights exactly the disclosure issues that we're here discussing. That hypothetical, that is exactly the type of math that we put in the model disclosures to model out exactly what those hypothetical future payments are so that the consumer knows exactly what it will be. And it also highlights exactly why the existing mortgage regulations absolutely simply don't work for this product. So it's not a function of a desire to not comply with TILA or any of the other. It's that TILA requires things that this product simply doesn't have. That's what the model disclosure is designed to do, so that a consumer looking at that will know exactly what does that 4% appreciation over 10 years or 30 years, what exactly is the number, what does it look like? So I just wanted to clarify that. Thank you.
Could I please expand on that a bit, if I could? I want to make sure you understand, mortgage loan disclosures present cost as a single percentage number, called an APR, right? That doesn't work here because the cost is unknown up front, because we don't know what the future home value will be, and we don't know how long the homeowner is going to stay in the contract. So you can't disclose cost as a single number. You would automatically be wrong almost every time. Once in a while, you might get it exactly right, 1 out of 1,000 contracts or something, but you can't do that. So what we do is we show scenarios. We present tables to the homeowner. The tables are organized by time and home price scenarios. So, for example, our company has a 10-year contract. We have a table that shows one column for each of the 10 years, and then each row corresponds to a different future home price scenario. Up 4% a year, up 6% a year, up flat, down 2% a year. We show that. And for each of those different scenarios, which is a combination of a future home price scenario and an ending year, we show the ending home value, the payment, and then we annualize it so you see it on a percentage basis. So you can compare that to the cost of a loan. But always remember that comparing to the cost of the loan is not an apples to apples comparison because you don't make any monthly payments with this, and that's worth a lot. You can't really capture that value of that when you present it as an annual number. But we present the number anyway so people can compare it to the cost of a loan.
Thank you. Peter Fertiz?
Thank you, Chairman. So this is all spelled out for the client,
Absolutely.
and they know exactly what's expected of them at the end of the contract.
Yes.
Now, at the end of the contract, how does the client pay it back? In a lump sum, monthly installments? And then what is the length of that
It's a lump sum.
payment plan?
It's a lump sum.
Oh, it's a lump sum.
Yes.
And if they cannot pay that lump sum, what happens?
If let's say they reach the end of the term, if they don't want to sell their home, a lot of them will be able to refinance into a mortgage loan, for example, to source the funds to pay us off, or they could refinance into another one of our contracts to pay off the original contract. So they have options.
So then they go back to traditional bank, or they go back to another providing.
They can go to a lender, or any type of lender, to get a mortgage loan.
And I would note that, at least for our company, about 90% of the people who pay back because they either sold the home or they had refinanced the home. And so they're paying back well before the end of the contract.
I'd like to raise one more point, if I might. Please indulge me if you could. Earlier, we talked about the mechanics of this product, right? Our product is based on a multiplier, right? And we used a 2.0 multiplier for our example. And Matt's product, Point, is based on a sharing the change in the home's value using a risk adjustment up front. And those things sound like, I'm sure they sound like new concepts to you all, right? And they are. But there's nothing inherently wrong with those things. Those are simply the mechanics of our contract. That's how we generate a return. That's how we price the contract. In the same way that there's nothing wrong with the interest rate on a loan, right? That's the mechanism by which the lender gets their return. So those things that we do are just like, we don't have interest rates. We don't have those mechanics. Our mechanics work like that. And once you get used to that, then you see it's quite different from a loan.
Please forgive me if it seems like I'm interrupting sometimes. We only have the room for so long, and I don't want to, I want everyone to have a chance.
Sure.
I'm sorry, Representative. Any other questions? No, thank you. Representative Torzik?
Thank you, Mr. Chairman. Just a quick question. You had mentioned Penny, Bruce, and Sophia had given you letters of endorsement. Were any of those letters come from the Amazon gift card incentive?
So I can talk to that. So yes, I don't know specifically because some of those customers were not from our company, so I'd have to go back and look. Just to be clear, yes, we did provide an incentive for people to provide testimony. We did not screen anything, and we also gave everyone contact information to contact all of you directly. I think that's exactly how maybe Representative Incap was contacted. So this was not the only way for people to provide testimony. Unfortunately, we had a very short turnaround time for this committee hearing because the deadline to submit written testimony was so close to hearing about the hearing today. So that is one of the reasons why we facilitated the payment, just to collect quickly the feedback. Yes.
Are any of you registered as principal lobbyists?
I don't believe so.
Okay, thank you.
Representative Harris on Zoom or on Teams, whichever we may be using today.
Yes. Good morning, Chairman. Good morning, panel colleagues.
Representative, if you can get a little bit closer to your mic or speak a little bit louder. Thank you.
Yes. You hear me? You hear me better?
Much better. Thank you,
Hear me
Representative.
better? Okay. I think will be helpful to the consumer because the amortization sheet is based on a 30-year payment calendar. I don't know the feasibility of it, but if the consumer can understand a 10, 20, and 30-year payment on amortization, how much more would you have to pay? And like to catch up with the interest, because the interest doesn't really kick in until about a 20-year payment. And then after that last 10 years, and then the interest rate kind of disappears and you start paying on the principal. So you think that that's possible for mortgage companies to incentivize?
Anyone that would like that question?
I mean, do you understand what I'm asking?
Could you clarify a little? I'm not sure if you're talking about existing mortgage providers or the shared appreciation home equity products. So we don't.
No, I'm talking about, yes. Go ahead.
The home equity products don't have interest rates. That's fundamentally what we're here discussing, and the challenges of complying with the existing mortgage regulations is that we don't have a single point to calculate, which is why we created this the disclosure documents, which show the hypotheticals so that they can understand what the consumer would pay in each potential use case.
And I just, for the committees, so it understands, there is no principal amount that amortizes over the life of the contract. So there is there's no pre-established payment schedule that you would see with a mortgage. When everybody gets a mortgage, you can see all 360 payments for a 30-year mortgage, and it'll see what's being allocated to principal and what's allocated to interest. This product doesn't have that structure.
Thank you.
Well, that's right. Thank you. Okay. Well, I thought that would be instrumental in helping consumers. I understand, what you're advocating with the shared account, and that's commendable, but, just on a general amortization just for consumers in general, if people understand that, they can kind of pay their homes off a little quicker if they understood the math a little better. But thank you.
I think one thing to the representative's point is, as mentioned, we can't do an amortization table because the product doesn't have that feature. But in our model disclosure and in some of the disclosures we offer in other states, including Maryland, which requires this, you have a grid-based disclosure, similar in some respects to the TALC disclosures that are required for reverse mortgages, that show a grid based on home price appreciation and the amount of time that has passed. That then you can look at those and then look at the equivalent APR for that scenario. Okay, so our products feature that so that the consumer can look over a variety of different scenarios and understand what the effective APR would be. So that would be the closest similar disclosure to an amortization table that we offer.
Anything else from Representative Harris? Thank you. Are there any?
No, thank you. No, thank you.
Thank you, Representative. Are there any other questions from the legislative? Representative?
Just a follow-up. When Representative Venkat opened up, you mentioned working with the banking regulation and the general attorney's office, correct? And I believe one of you testified and said that we should go back and work with the banking regulations, but it sounds like we've already done that. So I'm just confused. Why are you opposed specifically?
Well, I think a couple things. One, the Department of Banking in the past has said that this law doesn't apply, that they don't think that the Act 6 should apply to this product. And so that's a change from where they are. And I think we've been trying to lay out some of the practical issues with just this bill's application of Act 6 to the product. Just to be blunt, we do not oppose regulation. We have supported regulation and tailored regulation in other states. It's just the way this bill is written. This bill just simply makes one change to the law. It applies the baseline first lien usury cap limit to this product. And as a result, it creates all sorts of compliance problems that operate as a de facto ban. And so we are more than happy to work with the AG's office and the Department of Banking and Securities to get a practically effective regulatory scheme in place. It's just not this bill as currently written.
Any other questions?
I don't want to hold up the process. It's just that I like specifics. Like, what are the compliance problems? What would strengthen this bill to provide consumer protection specifically?
Well, we have the model bill that we submitted as part of our testimony, and that has a lot of provisions in it. But just to give a general overview, you have a list of required disclosures. You could use the model disclosure we've developed or the disclosure that has already been put into effect by Maryland and adopted by Connecticut. And Illinois is also about to release its model rules around this product. That should happen sometime this month. And that will probably also have a lot of detailed information. We helped with the department there develop. The Illinois law requires things like consumer counseling for this product. And so there will be some details there on that. It also has, issues around offering potential. The model bill has other provisions like offering rescission periods or requiring certain periodic statements or, again, offering counseling. Ability to repay requirements has come up a lot. We don't oppose education. We don't oppose disclosure. But again, the way that it's written, it only applies effectively to amortizing traditional loans. There's a reason why it doesn't apply to HELOCs, and it can't apply here. And without some sort of tailoring, the way this bill is written, it would just directly require compliance with traditional ATR, and that just can't work. So again, I would look to the model bill in the testimonial packet for more details, but we can certainly follow up with afterwards with some additional information on this.
To be clear, what we want in regulation are the same things that mortgage regulations have. Okay, mortgage regulations require licensing, reporting. They require caps on costs and fees. They require certain specific disclosures, and they lay out prohibited practices, like you can't do false advertising and things like that. We expect to have all those same things apply to us, but each individual provision has to align with the unique mechanics of our product. Like, we can't disclose an interest rate. We can't conduct an ATR underwriting because we don't have a monthly payment that we're trying to solve for. Like, the regulations just have to be tailored for, but we expect the same types of regulations. We expect everything that mortgage regs have. We expect the same thing in scope and spirit, but the mechanics have to work. And that's what our model bill does.
Thank you. I apologize for keep saying this. We are on if we can just tighten up the answers a little bit. Mr. Torzik, did you say you had one more before I finish it out? Nope, thank you. I just have a couple quick questions. It wasn't an accident I asked Representative Venkat a couple questions, because I do realize we have lawyers on the panel. With that said, I'm just going to ask a couple quick questions very quickly. And I think the gentleman may have already answered. Was the members on this panel aware that there was incentives being offered for positive testimony for the product?
No, I mean, that was just our company. No one else was aware. And I want to be clear, we did not offer incentives for positive testimony. We offered incentives for testimony.
Nobody else was aware of it? You'd brought up the Urban Institute. Were they paid for the report of which you use?
It's an independent study. I mean, it's noted on the report. I believe at the end, talks about it being an independent study. So,
it wasn't commissioned by any member of this organization?
I mean, it's correct, and as noted, our data was shared with them. That's different. I mean, we talked about the 55,000 records.
Yeah, I'd refer the committee to the final page of the report with respect to Urban Institute's statement.
Okay, thank you. Just a quick question. What's the average credit rating of your borrower? Or should I say, how low of a credit rating will you loan to somebody for? 620, 750?
That's one of the nice features about our product is we can go lower because we are not underwriting to a monthly payment like a lender is. So we have gone as low as 500. Average credit is typically in the mid 600s.
Okay.
The average person doesn't get that large a payment as we did in our example earlier. The average payment from us is about 15% of the home value. The average age is about 50 years old. They've been in the house for 10 years. they have a pre-existing loan that has about 40% loan to value. That's kind of what the customer typically looks like.
So basically, you don't get many customers like Chairman Lawrence and I with credit ratings at 840.
We have plenty of those, actually.
No.
We have a lot of customers that have very high credit scores, plenty of income, prefer the product because they don't have to make monthly payments to access their equity.
One last question. I find it interesting that in your product, that if my house goes from $500,000 to $750,000, the amount of money I owe at the end of 10 years is then calculated on the $750,000 ratio. If my house goes from $500,000 to $350,000, do I owe less?
Yes,
You do?
absolutely.
So do I owe less than the
We'll get the same
125?
percentage.
So is it?
If we go back to the example we did earlier where we were going to get 50%,
Yeah.
right, then it would be just 50% of whatever the number is at the end. It
So-
doesn't matter if it's up or down.
So basically, it would be just 50% of 175.
If it went down that low, yeah.
Yeah. Okay. Any other?
And that would also be true for our product as well. If
I'm
you're-
sorry.
Sorry, the two different models, that would also be true for both models.
Okay. Thank you. With that, if there are no other questions, I want to thank you all. Thank you.
Thank you.
And I forgot to do something why your get up at the next presenter would come forward. I forgot to do the roll call, not thinking since it was a hearing we had to take one. I apologize, Katie. Katie, could you do the roll call one more time?
Yes. Chairman Lawrence,
I'm here.
Barger,
Designation.
Marla Brown,
Designation.
Diorsi,
Designation.
Gatos,
Designation.
Glime,
Designation.
Labs,
Designation. And
Marcel.
I believe Representative Labs is also still on the call.
Yes. Marcel,
Designation.
Olsummer,
Designation.
Shuren,
Designation.
Schaefer,
Designation.
Torzik. Here. Chairman Conklin,
Here.
Bellman,
Leave.
Amon Brown,
Leave.
Carroll,
Present.
Sapita Fertiz. Here. Deefus,
Leave.
Harris,
Present.
Kenyatta,
Leave.
Monroe,
Leave.
Nelson,
Leave.
Parker,
Present.
Yelly,
Leave.
Rab,
Leave.
Sanchez.
Leave.
Thank you.
Ian, if you could come forward. Ian, would you? I don't have your full name up here. I'm sorry. I apologize. Oh, there. Sorry, Ian. Ian Carlton, if you could stand.
Yes.
Do you swear and affirm that the testimony that you are about to give is true and correct to the best of your knowledge, information, and belief?
I do.
Thank you very much. With that, the microphone is all yours.
Thank you very much. Chair Conklin, Chair Lawrence, and members of the House Commerce Committee. I appreciate the opportunity to testify today on House Bill 2120 and how it will help prevent vulnerable Pennsylvanians from falling prey to a new brand of dangerous high-interest home equity loans. Yes, high-interest home equity loans characterized by large lump sum payments, known as shared appreciation agreements. This bill will amend our usury law, commonly known as Pennsylvania Act 6, to clarify that the definition of residential mortgage includes shared appreciation agreements, thus subjecting them to a host of important protections already in place for all other residential mortgages in the Commonwealth. To be clear, this bill does not ban shared appreciation agreements. We've heard the testimony from our colleagues in the industry that they are working with Illinois, Maine, Maryland, Connecticut, all states that have legislated that these are residential mortgages. We have not heard that these products are not operating in those states at this time. What this does is it subjects them to the same legislative safeguards that exist for all other residential mortgages in the Commonwealth. My name is Ian Charlton. I'm an attorney at Community Legal Services of Philadelphia. We represent low-income Philadelphians in various legal proceedings. My team works with low-income homeowners, hundreds per year. We're familiar with the fallout of the predatory lending bubble of the early 2000s, and we still help clients who are facing foreclosure on pre-2008 loans, some of which have matured with unaffordable balloon payments, like the lump sums that will come due with shared appreciation agreements that we just heard about. Over 50 years ago, the General Assembly recognized that homes are unlike any other asset and passed Act 6, creating fundamental safeguards for residential mortgage loans. Those include interest rate caps, number one. Number two, mandatory notices to the homeowner before the lender can proceed with a foreclosure. Number three, a right to cure any default up until the date of sheriff's sale. Our office has seen the benefits of Act 6 play out in countless foreclosure cases for Pennsylvania homeowners. Interest rate caps thwart unscrupulous lenders from bilking Pennsylvanians. Mandatory pre-foreclosure notices, which itemize amounts due, allow homeowners to review what is being claimed is owed and contest things like unlawful interest and fees. The ability to cure up until the date of sheriff's sale gives homeowners the time that they need if they are able to refinance out of the delinquent loan. So these are very important protections. Over the past couple of years, new financial products that we just heard about, known as shared appreciation agreements, have emerged. These did not exist when when this body enacted Act 6. They are targeting vulnerable Pennsylvanians. As you heard, as you may have seen from the testimony that was submitted on behalf of the industry, people who are income modest, quote unquote. And these products seek to bypass these protections. Although they utilize seemingly endless and complicated agreements, which do confuse consumers, as we know when we look at the CFPB's publicly recorded consumer complaint database, where some consumers have said, we felt bamboozled by these products. They offer homeowners money up front in return for a share of the home's future value when the loan matures, often within 10 years. They try to get around mortgage protections. You heard the testimony today by saying they're not really a loan and no interest is due. But in actuality, they put a lien on the home. They put a lien on the home, and they are rigged against homeowners to provide big returns for the lenders. You heard about the risk adjustment that they use. So your appraised value of your house is set at an artificially low level when you get the loan, so that they can make sure that they're insured against the risk. They could force people to sell their homes at maturity in as little as 10 years when the whole debt comes due in a single payment. According to the CFPB, which put out a report on this in January of 2025, these loans, quote, carry features that echo some of the risky loan structures that were common in the lead up to the 2008 housing crisis. Again, by their own written testimony, the industry is selling these loans to folks who are, quote unquote, income modest. Plus, according to the CFPB, the average customer is somebody in their 50s, which means that if they're not already seniors, they will be when the balloon comes due. Not surprisingly, the AARP, in its 2025 policy book, has said that these lack core consumer protections. When a consumer borrows money against their home and puts the home up as collateral, that transaction carries the same risks as other residential mortgage loans. Why are we calling it something else? It should be subject to the same protections, which, at their most fundamental, require a judicial foreclosure process in Pennsylvania, where the homeowner may raise defenses and the court must determine ultimately whether there's been a default and before the creditor can proceed to a sheriff's sale. But various lenders are peddling shared appreciation agreements. We've seen them recorded in Philadelphia, originating loans with provisions that allow them to act as power of attorney for the homeowner and to conduct a sale of the homeowner's house at a public auction, all without going through the court process, should they deem the homeowner to be in default. These terms are unlawful, and on these terms, the lender is judge, jury, and executioner. By amending Act 6's definition of residential mortgages to clarify that it includes shared appreciation agreements, the General Assembly can ensure that these lenders engage in the judicial foreclosure process, send Act 6's mandatory pre-foreclosure notices itemizing amounts owed, respect the statewide right to cure the default up until the sheriff's sale, which has existed for over 50 years, and cap interest rates. These protections ultimately have been in place for over 50 years. They go to fundamental fairness. Without subjecting the industry to Act 6's protections, many who enter these agreements will be forced to sell their homes due to the sheer size of the balloon, a product of the outrageous 20% interest rates sought by the industry, which you can see in the FAQ of the Coalition's website. Many will not see the 10-year balloon coming. With slogans like no monthly payments and no interest, and where contracts begin with the 5 words, "This is not a loan," it should be no surprise that many Pennsylvania homeowners will be broadsided when the balloon hits. That is exactly why the Act 6 interest rate cap is so important. At the current cap of 7%, which is set by the Department of Banking, a customer who took out a $44,000 loan in 2022, shared appreciation agreement, would owe a total of $61,000 by 2032. At the rate sought by the industry of over 20%, that same customer would owe over $102,000 in that same time frame, eliminating any hope for a refinance. Without any limits on the interest rate, a forced sale would be a foregone conclusion. And we heard from our colleagues in the industry, what happens at the end if they can't afford this? Well, they glaze over the fact that if they don't want to sell their home. Many will be forced to sell their homes. But the industry says, oh, well, they'll be able to refinance out of it. If the median customer here is in their 50s, what kind of income are they going to have 10 years later to refinance out of this, especially when you're going after people who are income modest, quote unquote, from their testimony? Now for the fundamental point. We've heard from the industry that shared appreciation agreements do not have interest because they are not loans. And according to the industry, they are not loans because the lender has the option to not call the loan in when it is due. They didn't say that today, but that's what you see in the court cases that are percolating all throughout the country. That's what you see on the contract itself. This is an option. It's not a loan. Let's be serious. They give you upfront money and put a lien on your house to secure that money. That's a mortgage. They exist so that the company can share the value of the appreciation of the property. If the homeowner will need to pay back more than the amount they originally borrowed, that is interest. That's the entire idea behind this product's design. If it looks like a duck, walks like a duck, quacks like a duck, you know the rest. In sum, the General Assembly, in its wisdom, provided Pennsylvania homeowners critical safeguards to save their homes when it enacted Act 6 in 1974, over 50 years ago. These safeguards have helped thousands, countless of Pennsylvanians save their home from foreclosure. We should strive to ensure that our usury law continues to meet the challenges posed by new and dangerous products as they arise on the market, products which threaten the housing stability of thousands of Pennsylvanians. That is exactly what this legislation does. Thank you for your consideration of my testimony.
Thank you, Ian. Chairman Lawrence? Any other members with a question for you? Scipio Freitas?
Yes. How many cases have you dealt with at the end of some of these contracts?
So yeah,
And
that's a
what's
good.
been the outcome of those cases?
That's a good question. Right now, we're tracking how many are recorded in Pennsylvania, and we know that it's a little bit over 2,000 have been recorded in the last few years. We haven't dealt with a foreclosure resulting from this yet. The reason being, these products are new. The overwhelming majority of these products have been recorded, at least in Philadelphia, have been recorded in 2024, 2025. We're not going to see this crisis hit for, at least 5 more years, maybe, 2034, 2035. What we're trying to do is get ahead of it. So we haven't, to answer your question directly, we haven't seen, as the industry, alluded to earlier, we're not going to come here with homeowners who are being, who are saying this is a disaster, but that's only because it's not due yet.
May I follow up?
Yes, please.
You said this product is new, and this is and I want to thank the makers of this bill because I never heard about this prior to reading this bill. So thank you for that. You said the product is new. How new?
Well, we have, if we look at publicly recorded mortgages in the city of Philadelphia, like I said, the overwhelming majority, if you look at Point, HomeTap, the companies that we're talking about here, have been recorded in 2024 and 2025. I think maybe you start seeing them recorded around 2021, 2022.
Torzig?
Thank you, Mr. Chairman.
Representative?
Thank you for your testimony. Have other states had a longer run with this product? Are some of these cases showing up?
My understanding is that, these products really proliferated in the post-pandemic sort of era. And that's why you're seeing, we're looking 5 years down the line. And that's why in the last year or two, we've seen legislation from states like Illinois, Connecticut, Maryland, and Maine. This is all new legislation, because we haven't really seen. And, I would defer to my colleague at the NCLC who's going to be, speaking after me. But I don't think nationwide we've seen too much. But I believe that, my colleague at NCLC who's more familiar with the national scene can answer that better.
Thank you very much.
Yeah.
Visiting our beautiful capital.
Thank you very much. Thanks for having me.
Are there any other questions? If not, I just have a couple. So when you're looking at folks, and the reason I asked the question, the average, what their credit scores were, because for full disclosure, I was a builder, national director, 250 homes a year. I'm very well integrated into the mortgage system, except I'm learning about this one. But one of the reasons I ask is because folks who have a lower credit score have always been prey for predatory, and I'm not calling this predatory in any way, stretch, matter. So please, the gentleman, please don't think I am. But as a lawyer, and I'm sure you've done more than this, helping citizens out. When you get it with those individuals with a 500, 550, is it there because, do most of them mean to get in financial trouble, or is it just that many of them lack the understanding of finances when they sign a car loan or a home or any other type of product? And the reason I say this, I'm very familiar with the RV industry, unregulated, no type of lemon laws. The idea that many dealers will give you never in writing, but always verbally will give you a $100 credit towards product if you buy a new home, if you give them a 5-star rating while you're sitting there. So I'm familiar with this, not good, bad, or indifferent. I'm just familiar with it. But I'm just curious, as your clientele, where does most of your clientele fall on this?
Well, there's a few things that are coalescing with our clientele. That's a great question. Many of our clients, were for whatever reason, are out of work temporarily. potentially through an injury, long-term disability, and they're trying to, get back on their feet. That can impact a client's credit. There's a lot of other people who, like you say, are just sort of unfamiliar with. A lot of people do not exactly know what they are signing in order to access credit. And that is just the reality of the country that we live in. We've all been there, signing agreements, at various places that are 40 pages long, where you say, "Oh, I guess this seems pretty legit, so I'm going to sign it." Unfortunately, that is also part of it, and that's why the industry's sort of, their way to try to get ahead of this is saying we're all in favor of disclosures. We can really push disclosures here, but we can't push subjecting this to the same legislative safeguards that exist for other loans. That's why that doesn't necessarily work. Disclosures are not the most important thing. The most important thing is acknowledging that this has an interest rate and that there should be a cap on the interest rate.
Thank you. No other questions? With that, thank you, Ian.
Thank you. Thank you very much.
Our next presenter is going to be Andrew. I messed this up. You can correct me. Pizer?
Pizer.
Pizer?
Pizer.
Pizer. Hey,
It's okay. Yes.
Listen, pie's my favorite day of the year, so infinite. With that, I will need to swear you in first. Do you swear to affirm that the testimony that you're about to give is true, correct, to the best of your knowledge, information, and belief?
I do.
Okay. With that, the screen's yours, I guess.
Great.
Go ahead.
Well, thank you very much for the opportunity to testify remotely. It takes a big budget to travel to Harrisburg. My name is Andrew Pizer. I'm a senior attorney at the National Consumer Law Center. NCLC is a nonprofit organization that focuses on consumer protection and promoting economic justice for homeowners and other consumers. We strongly support HB 2120. Shared appreciation agreements are high-cost loans. If they're not properly regulated, they will drain homeowner equity and force borrowers to sell. This bill will ensure that they're subject to the same laws as other mortgages and ensure that your regulators have the authority to tailor the regulations as needed. Now, others have submitted some very well-written testimony. I encourage you to take a look at it. Rather than repeat what they say, I'm going to try and focus on some key issues and respond to some points made by opponents of the bill. The most important aspect of this bill is that it corrects a dangerous misperception spread by the shared appreciation mortgage industry. They claim that their product is not a loan, it's not debt, and that is plainly not true. I'm aware they've submitted a letter from the Department of Banking that supports their interpretation, but that letter doesn't consider the real life experience of Pennsylvanians and other borrowers around the country. The way these contracts are structured and the way the industry cherry picks who they'll lend to virtually guarantees that the lender will always get paid back, and at a whopping effective interest rate too. So subjecting them to the existing usury cap should not be a problem. Some of these contracts already include caps, but it's an unreasonably high one, often 20%. They say their high rates are justified by the risk they take, but experience has shown that their risk of loss is actually no higher than traditional lenders face. These are asset-based loans. They're very careful to ensure that the collateral is enough to protect their investment, so their high rates are really nothing more than price gouging. Concern about how to disclose these products is a bit of a red herring. The question today is whether to clarify that they're mortgages, and how to disclose them is a question for the regulator. The regulators are the experts in that kind of technical detail. But a technical clarification that I wanted to address because it's come up today. The Federal Truth in Lending Act is designed to include loans that do not have a stated interest rate or an amortization schedule. It is definitely possible to calculate and disclose an APR for a shared appreciation agreement, especially if the regulator requires disclosure of the maximum possible payments under whatever cap is defined. We've also heard that the proposed bill is a de facto ban on the product, but we respectfully disagree. Shared appreciation agreements could still be made under the proposed law. Some lenders and investors may decide to withdraw from the market because the product would no longer be sufficiently profitable, but that should not deter lawmakers from protecting the public. The public does not need a usurious mortgage any more than it needs a hole in the head. The written testimony submitted to the committee includes a number of letters from satisfied borrowers, but while it's not clear from the letters, it sounds like none of them have reached the point where they have to pay off the loan. Based on our experience talking to borrowers who have reached that point, I suggest that most of those letter writers will no longer agree that getting a shared appreciation agreement was such a good idea. And if the committee thinks those concerns are too hypothetical, we can send you stories from homeowners in other states who have reached a point where they were asked to make a payoff. What's interesting about this product and very concerning is that it exploits a behavioral economics phenomenon known as hyperbolic discounting. Basically what that means is that all of us put less weight on a bill that's going to come due long in the future. And if someone gets a disclosure and statements early in the process or along the way, that's still very different from sitting down and having to write a check. And that is a problem that is inherent in this product. The no monthly payments and the big payment at the end is really what we've seen that most upsets consumers when they realize they're at a point where they have to sell their house to make a payment. When the payment comes due, it'll be massive. Tens of thousands of dollars, six-figure payments are possible. Some of the letter writers who submitted their testimony cited the ability to stay in their homes as a benefit, but they will almost certainly be forced to leave when the bill comes due. Other borrowers have told us they plan to use the equity in their home to pay for retirement, move into assisted living, things like that. But now they felt trapped because if they sold their home, too much of their equity, which is their savings, would go to the lender. CHEP has emphasized the findings from the Urban Report. Now, we just found out about it and haven't had a chance to review it thoroughly, but I would note that discussion of how it's less expensive than other credit options doesn't consider the personal cost, the risk to the homeowner when that balloon payment comes due. We are particularly concerned about what will happen to older and low-income homeowners who must forfeit a large chunk of their equity when these contracts force them to sell their homes. Given the high cost of housing today, will their remaining equity be enough to find replacement housing? What will happen to older borrowers who have had to pay down their mortgage over time in the years they've been in their house and had hoped to age in place, but now they have to sell? These are policy decisions that legislators need to weigh against how much return lenders should expect on their investment. We think HB 2120 strikes a fair balance and leaves room for regulators to make adjustments as needed. Homeownership is important because it gives families a chance to build wealth, but it's more important because it provides a safe place to live. Shared appreciation agreements, in the absence of the common sense requirements in this bill, will put all of that at risk. Thank you for your time.
Thank you for your testimony. Any questions from the members? Chairman Lawrence?
Thank you, Madam Chair. Thank you for your testimony. I appreciate you appearing virtually before the committee today. Again, as I mentioned earlier, I think there's a lot of folks who might be listening to this hearing who might not be familiar with the products that we're talking about. Could you maybe, and I realize I'm putting you on the spot, but could you explain to those who are listening to the committee here, perhaps, the general differences between a shared appreciation agreement and a reverse mortgage? I think there's certainly probably more familiarity with reverse mortgages in the just in the general population, but perhaps you could outline the difference between those two instruments.
Sure. Kind of technical details. Reverse mortgages have a contractual interest rate that's written into the agreement from the beginning. Another critical difference is that reverse mortgages, the borrower, the homeowner, can stay in the home until, well, as long as they need to. The payment doesn't come due until the borrower needs to move out of the house for whatever reason. These contracts, shared appreciation agreements, have a defined maturity. No matter what, the payment's going to come due at a date certain. From what we've seen and what I've read, most shared appreciation agreements, and again, it's a new product, so it's not a long track record. They're like traditional mortgages in the sense that people don't usually keep them till maturity. They get out of them for whatever reason, selling the house, something else before maturity. But when most people get a reverse mortgage, they're planning on staying in their house as long as possible. That's why we think they're a safer product than this, is because you're not being forced out. And frankly, a lot of people, by the time they move out, they're going into a nursing home or they're passing away. So it's not as much of an issue. There's a lot more regulation of reverse mortgages too.
Thank you, Madam Chair.
I hope that helps.
May I continue? Thank you, Madam Chair.
Yes, you may.
So, thank you for that explanation. Speaking more directly to House Bill 2120, the bill proposes to add shared appreciation agreements to the definition of a residential mortgage as that term is currently defined in Pennsylvania statute. So as you look up the relevant statute, for those who don't have it in front of them, the terms are defined, and then it goes, the statute is lengthy, and it goes through basically how are we going to regulate mortgages in the Commonwealth of Pennsylvania. And it's lengthy, and it should be lengthy, and there's a lot of specific details in it. I'm not going to ask you about specific details, but just a quick search here shows that the term residential mortgage, which is a defined term in the Act and which is being proposed to be amended by the House Bill 2120, appears 82 times throughout the Act. So many of those times the term residential mortgage is being used to do, for a residential mortgage, X must be the case, Y must happen, Z rates are calculated, et cetera. So for example, I'm looking at the definition of a further defined term, loan yield, okay? And I think one of the challenges with House Bill 2120 is that and I think perhaps the argument that was made earlier is that the shared appreciation agreement doesn't neatly fit into the existing law's definition of what we typically think of as a residential mortgage, and then how that term is then further utilized throughout the existing Act. So for example, the term loan yield, what is loan yield? Well, it means the annual rate of return obtained by a residential mortgage lender from a residential mortgage debtor over the term of the loan. And how do we figure that out? Well, it's determined by regulation, and the regulation is a finance charge amortized over the contract term of the loan. So I guess, and I realize I'm giving a lengthy setup, my question is that it does seem to me that it would be challenging under the existing statute if you simply add shared appreciation agreement into the current definition of what a residential mortgage is and then follow it through the entire Act. I do think it presents some challenges to how the existing law would apply to these agreements, simply because it doesn't neatly fit within the Act. And some of these actions that are required in the Act to be applicable to all residential mortgages don't neatly fit into this shared appreciation agreement model. So my question to you is how would you respond to that point, which I think there is some validity to that point. How would you respond to that?
Well, not being a Pennsylvania attorney, and I know you have limited time, so we can't go through all 82 references, but
certainly,
I think the general response is that regulations exist, and banking or any regulator exists to address the nuances that come up with individual products. Legislation isn't cookie cutter. It never addresses everything perfectly. So the regulators usually have authority to fine tune things. The reference to calculating the loan yield, however, is one example of how statutes are drafted generally to be attuned to that issue, the need to be flexible. The loan yield references finance charge, which is also used in the Federal Truth in Lending Act, which I'm more familiar with. And those laws like that address the fact that not every financial product has a classic interest rate in quotes. There are other ways for lenders to make money off of extending credit. And the loan yield, the finance charge are tools to just step back and look at the big picture of how a product works rather than being hung up on the technical details. You could say, well, it doesn't have a defined interest rate, so there's no interest. But lenders have gotten around usury caps for centuries, and regulators have been attuned to that. So they define statutes functionally. Courts are accustomed to doing that. They look at how things work out in practice rather than, it's putting function ahead of form. So I think there is enough flexibility to declare these to be mortgages and still adjust the nuances of the statute. Other states have done the same thing. We've heard that I think it's about 4 other states have declared them to be mortgages, and they face similar issues, and they seem to be working it out.
Thank you, Madam Chair. Thank you to the testifier.
Representative Twardzik, did you have a question? You wave off. Any additional questions? No? Well, thank you so much for your testimony. We will proceed with panel 4. And panel 4, we have Wendy Gilch and David Friend. We will have to swear you in. I believe David is virtual. Are we ready? Okay. We'll need the witnesses to please stand and raise their right hands if able. Do you swear or affirm that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief? Great, thank you. We may proceed.
David, do you want to go first, or would you like me to go?
You can go ahead, Wendy.
Why, thank you, David. Okay. Sure. Is that better? Good? Perfect. Okay. Thank you for having me today. My name is Wendy Gilch. I am a PA resident from the Sheets side of Pennsylvania, not the Wawa side. I am also a fellow at the Consumer Policy Center and the founder of Selling Later, where I specialize in consumer real estate education. I'm here to support the bill, and I want to use my time to focus on 3 things very quickly because I know that we are running a little short on time, and I've already submitted the full testimony. First, when a lender runs an ad for a mortgage product that highlights fees or lack thereof, repayment terms, interest rates, the law requires them to disclose certain things and the costs within that advertisement. But because the state hasn't caught up to this product yet, these companies really have a lot of wiggle room to say a lot of things in the advertisement that diminishes the true cost or explanation of what the product will really cost them at the end. One company in their recent press release to journalists said, "The seller never pays it back, the buyer will pay it for you," implying they walk away with cash with no financial obligation. One ad that took me to Unlock gave viewers the impression that you just give $10,000 back that they lent you. The advertisements are engineered to eliminate the pain of payment, removing the signals that we as humans rely on to understand how much something really costs. And it's worth noting when we talk about who's targeted in these ads, plenty of the ads that I have reviewed and saved specifically talk about how there is no credit check or low credits, which to my impression tells me that they're targeting certain individuals that may not qualify for specific loan products. Another publicly described its product as debt-free cash with no interest and no monthly payments, while confirming in that same interview that their annual rate return can be up to 20%. Which is a very enticing rate for the Wall Street investors buying these contracts on the secondary market. If I, a homeowner in the state of Pennsylvania Sheetside, used this product in 2019 and received $50,000 from my Pittsburgh home, I would walk away with about $46,000 after all of their fees. Please note that some also add a risk reduction, but because that is not even across the board, I did not deduct that, but there might be even lower amounts given to me. And if I closed that agreement today, I would owe $126,000 at settlement. And comparing that to a home equity line of credit, known as a HELOC, on that same amount, I would owe roughly $60,000 less. What's more concerning is that some of these companies are not marketed to people who have options. It's marketed to people who can't qualify for a HELOC. And the affordability issues in our state are not going to be solved by charging more to those who are already in a poor situation. It essentially just creates an expensive delay to a problem instead of solving it. Thirdly, I know, as has been mentioned in my testimony, I talked about MV Realty. And while I could go on forever about the similarities of how the state did not act in time, the reason I included it is because, yes, it was a bit of self-regulation. MV Realty products were a new product. At that point, there was no term limit on how long a listing agreement could be. But unfortunately, the state didn't act quick enough, and there are still 1,000 homeowners who are locked into a contract with MV Realty who will likely have no money to pay them back once the state of Florida, who has already settled with them, receives their payment. The majority of testimonials submitted for today against this had two things in common, in my opinion. Some sort of financial issues, not necessarily distress, but mentions of debt, credit cards, at the time of signing. And majority of them, in my opinion, did not state any sort of settlement payment has been made. And just because someone can't qualify for one product does not make it acceptable to charge them nearly 3 times more for another. I'm sorry, one more thing. Many homeowners who signed these agreements back in 1921, 22, are still likely within years of being able to pay the settlement. Most of the contracts haven't closed yet, and the sticker shock has not hit. It's the psychological painlessness of never writing a check by design, and it's exactly why it's very easy to get glowing reviews for these existing products, because many of them have not had to pay the bill. And while consumer testimonials make it sound like this bill would remove shared appreciation agreements, that's not what it's aiming to do. The bill lets them exist, but as a regulated mortgage product, subjected to the same consumer protections that Pennsylvania has applied to every other home secured product. If this product thrives on a based opportunity, let me go back. If the product thrives based on the opportunity of up to a 20%, in their words on HomeTap's website to investors, risk-adjusted return to investors, you have to ask if it's actually a beneficial product to consumers or for the investors who are buying them on the secondary market.
Thank you so much for your testimony. If we can proceed with Mr. Friend's testimony, please.
Certainly. Thank you, Chairman Conklin, Chairman Lawrence, and distinguished members of the House Commerce Committee for the opportunity to discuss shared appreciation mortgages and House Bill 2120. My career has been involved with residential real estate since the 1990s. Most notably, I worked at HUD and CFPB for 13 years on issues related to federally related mortgages. My written testimony focused on an example of how a provider calculates the amount due at the end of the contract's term, as has the testimony of others. I'd like to focus more on how the other aspects of those home equity sharing agreements work and how they can impact consumers. Not all providers have the same provisions, but the covenants of most agreements address several issues, all requiring pre-approval of the holder of the agreement. First, future transfers of any ownership, arm's length sales, transfers between spouses, transfers to family members for estate planning purposes, are events that can trigger the exercise of an option or vesting of other rights under the agreement. Second, refinancing of any existing obligations or new loans require pre-approvals, and some are explicitly prohibited under the agreement. For example, other home equity sharing agreements, reverse mortgages, unrecorded loans, and some others. 3, renovations above a certain dollar amount typically need pre-approval. Some agreements include a process to adjust their equity share if the consumer is using their own funds to finance improvements. Others make no changes to the allocation or have stringent contingencies on when the allocation can change. These future events all trigger a new assessment, a new appraisal, or a new automated valuation model to determine the value of the property, requiring appraisals and additional fees to be paid by the consumer at that are added on to the outstanding balance. These pre-approvals and the additional costs associated with them are not required, or there's no direct analog for federally related mortgages. These agreements also can contain waivers of rights of partition and other common law causes of action, and also mandatory arbitration provisions in the event of disputes. I know there is discussion concerning the priority of liens securing these types of agreements. While the lien itself would be held subordinate to any purchase money mortgages, the level of pre-approval and control over the property from the covenants in the agreement are more analogous to a fractional ownership relationship and go beyond repayment of monies advanced. I've heard some testimony related to the disclosures that have been provided. I've looked at them. I have experience with this, with the TILA RESPA integrated disclosures from the CFPB. From what I can see, they contain quite a bit of information overload. In other words, there's so much information that the consumer can't pick out what information they need to make an informed choice. There's a lot of plain language issues, a lot of sentences that appear to be drafted by lawyers and are not tailored to the reading level of most consumers. They repeat defined legal terms that are already in the agreement. They contain inconsistent terms. They use the same words differently in different contexts. And sometimes, for example, the word settlement is used in two different contexts in the same disclosure. I'll mention one more thing. These types of agreements were used in the United Kingdom. The Bank of Scotland originated some shared appreciation mortgages for retirees back in the 90s. It has generated a lot of controversy and a lot of press information, press reports in the British press. Their regulator, the Financial Conduct Authority, deemed that they didn't have jurisdiction over some of the practices. And I think that can be used as a reason why these types of arrangements and these types of agreements should be covered by appropriate regulation. I'm happy to answer any questions you may have. Thank you.
Thank you for your testimony. Do we have any questions from our members? Jeremy?
Thank you, Madam Chair, and thank you both for being here, both in person and virtually. I do go to Wawa, so in the interest of full disclosure, I actually was at Wawa this morning. But Sheets, it is what it is, right? Appreciate you being here today very much. I'd like to pose to you the same question I posed previously. Just the challenges. I mean, we heard testimony earlier from some folks from the industry that, for example, in some of these instruments, the value of the eventual payment back is going to be dependent upon the final value of the property and how much it's increased or decreased since the initial transaction occurred. So there's a variability there. So it does strike me that it would be difficult to calculate what the interest rate may or may not end up being when you have a future final figure that is unknown. So how would you respond to that? Because I feel like the reason that that's important is that a residential mortgage, as it's defined in statute, there are specific disclosure requirements about, and in fact, not just disclosure, but the Act speaks to how those interest rates can be calculated and how it should be figured, so on and so forth. So how would you respond to that? Because I do actually think that's a point that needs to be addressed, because I don't see, again, that the shared appreciation agreement neatly fits into the defined term residential mortgage in the existing Act, because it is difficult and maybe impossible to come up with what the interest rate actually is, given that we don't know what the end value is going to be for the transaction 10, 30 years in the future.
Yeah. Go ahead, David.
So in response to that, I'd note that I don't know. I'm not a Pennsylvania lawyer, so I can't speak to Pennsylvania law. But I believe that it's roughly analogous to the Truth in Lending Act, because if it wasn't, then there would be a question of whether it's preempted by the Truth in Lending Act. There are other mortgages that have some indeterminacy related to what the future balance will be, what the amounts will be due. I can think of adjustable rate mortgages, and most regulations contain some specific provisions that require redisclosure, that require based on when the rate resets. I think that you could certainly come up with something analogous using the calculation methodologies in these agreements to update the consumer over time, just like you have to with adjustable rate mortgages. I also would point out that some of the disclosures, some of the concerns related to future events and future balances would be similar to reverse mortgages, and there are some regulatory provisions that provide flexibility. To the extent that at least federal disclosures, something doesn't apply or something isn't, directly analogous, those provisions can be, at least on the federal level, can be removed from the disclosure. There are provisions in the regulations for that. There are some flexibilities, at least in the federal level. I'm not sure what the state level would be. The other thing I would point out is that the definition of finance charge in federal regulation, which I would assume is pretty similar in Pennsylvania, doesn't just include interest. The whole idea behind finance charge is a lot of the capturing a good amount of the costs associated with obtaining the agreement or engaging in the agreement. Some are excluded, some are included, which is a whole can of worms that I think is beyond the scope of what we need to discuss today. But there are flexibilities usually provided in regulations to tailor it. I'd also note that some existing products, at least I've encountered ones from the Muslim American community who has a religious prohibition on paying interest, have developed products that are more based on fractional ownerships, and I have seen those types of products disclosed under TILA-related disclosures as well. So there are ways that regulators have done in the past and can use to address some of the apparent incongruities from just reading the statute itself.
Ms. Gilch, did you have additional thought on that or no?
No, I think he explained that pretty well.
So I won't belabor the point, and I appreciate you mentioned adjustable rate mortgages, and I think that's I appreciate your thought there. I do think there's some fundamental differences there. I mean, if I know my interest rate is based on whatever prime plus 50 bips or whatever, right, up to a cap of 8% or whatever. I mean, that's again, and that's something that adjusts over time, and that's anybody knows what the prime rate, or can look it up, what the prime rate is going to be, but we don't know what's going to happen 15 years from now with the appreciation of a given property or the depreciation of a given property. I think the challenge is that regardless, the discussion here today is on the House Bill 2120 specifically, and then the overall concept, right? I don't think is there room to regulate this product or to, or to put into statute certain things or to add to regulations? Probably, right? But I do think there's a challenge with the statute as it's drafted, because the terms as they're defined in existing law, I don't think they fit exactly the product that is being described here. And I think the danger in just moving forward with just throwing it into that bucket, throwing this product into that bucket, is that you create uncertainty that will be exploited is not the right word, but there will be uncertainty, and that will end up in litigation. And that's litigation that the probably is not desirable by any party, but certainly the folks who have entered into these transactions probably simply just don't have the money to pay those legal fees, just to be candid, right? So I do think it's important to get it right up front with the statutory draft, with the language being drafted in the bill. I'll leave it. I have some other questions, but I'll leave it at that because I don't want to monopolize things. Thank you, Madam Chair.
Ms. Gelch, in your testimony, you reference a company operating under the name MV Realty. Based on your organization's extensive research into shared equity and similar alternative finance products, do you assess MV Realty's offerings as materially distinct from the practices and risks the coalition has outlined today? And if so, in what respects do they diverge, whether in structure, consumer impact, or regulatory posture?
So the MV Realty were listing agreements with a certain brokerage that offered them cash up front, and as long as at some point they sell their home with them, and they were given a 10-page legally dense contract, not aware that there was a 40-year lien put on their home, that if for some reason they passed away, that continues. And if the homeowner were to sell with someone else, the MV Realty was then dragging people to court for thousands and thousands of dollars. Now, it is not the same product, but I helped the Florida Attorney General with some research on this product and how these products were advertised to consumers. And that's where my concern lies in, is that it was very similar, no debt, no payments. And so when you present that to consumers with legally dense contracts, I think there's a big concern when we look at financial education and financial understanding. And so I see very similar situations here. The difference with MV Realty is that majority of states took too long to be able to regulate them and actually figure out what this product is. And so the reason I show them as an example is that the state took a little bit too long, in my opinion, to step in, and there's still thousands of homeowners stuck in these liens. And so that's why I wanted to share it, so that you understand the urgency of how quickly these products can grow, and when they're not regulated or they don't fit into a box, if there's not any urgency to move forward, it can really cause some serious financial damage down the road. Even if there's an unknown, it's important to address it now versus waiting for lawsuits to come down later.
And a follow-up to that question, because your testimony, you also mentioned that these organizations target certain individuals.
Yeah.
How did you experience that?
So unfortunately for me, the algorithm loves to show you whatever you find. And I actually fell upon one of their ads about a year ago, and it was talking about no credit check, couldn't qualify, debt-free, all those key terms like don't worry about your credit score. And in fact, at one point, there was a fake testimonial that led consumers to 2 different products. And that's actually originally how I landed on this company and why I met Representative Venkat, because A, that's illegal, but also you're baiting people in with advertisements that aren't even true, and baiting them in with the conversation of don't worry about your credit score, or some of them advertise they'll take a 500 credit score. And I think if any normal financially savvy consumer, in my opinion, at least for myself, if I were to really look at these products and I could qualify for a HELOC, knowing I would pay $60,000 less for a HELOC, depending on this term, I don't see a reason why I would go with this product.
Thank you. And I have a question for Mr. Friend. Given your respective experience and the depth of your research into these products, could you elaborate on what actually occurs when a home subject to one of these agreements loses equity? Specifically, does the investor's claim simply extinguish, or do contractual mechanisms allow the agreement to persist, and if so, in what form?
So from the few that I have reviewed, the agreement theoretically could extinguish, but it's completely at the option of the holder of that agreement. If the holder does not, in its absolute discretion, decide not to go forward with the agreement, it would go in place, and you would have to have a depreciation in value that is substantial. One of the things I would look at is kind of historical records of home price appreciation over 10-year periods. And I don't think that I'm aware of a substantial decrease in home prices over 10-year periods in the past since World War II. So that's kind of something that theoretically, yes, could happen. But from the agreements I've seen, most of them will generate some sort of return even even when the property depreciates over what was given to the borrower at inception. And so, the percentages can go down, but the return will go down if they continue to hold on to it. I don't think historically there's been home price depreciation that would get to a point where the somebody with this type of agreement would be in a position where they had less due than what they lent out. If you would go back through historical records of home price appreciations. It doesn't mean it can't happen. It's just historical record doesn't suggest that many of these agreements will end up as having a loss for the company.
Thank you, Mr. Friend. And before we move on to closing remarks, I'd like to know if the makers of the bill, either Representative Venkat or Representative Twardzik, would like to add some additional comments.
So thank you, Chair Cepeda Freites, and thank you to the committee for the time today. I just want to address a couple points that have been raised later in the hearing, specifically by Chair Lawrence. When we look at Act 6, and our staff is far more expert on this than I am, because I raised the same question that you did. Like, how does this product fit within Act 6? And it was rightly pointed out to me that Act 6 specifically has statutory language, in the wisdom of the people who drafted it far before I was here, to allow adaptations for particularities to a product in regulation. So when we are talking about disclosures under the Act 6 framework and amending in a definition of shared appreciation agreements into mortgage, we do have the ability through the Department of Banking and Securities to adapt accordingly to the specificities of this product. The second thing I would point out in that regard is that is exactly what has happened in every other state that has legislated on this. Illinois, Maryland, Maine, now being proposed in Massachusetts and others, they have said, this is a mortgage, go talk to the regulators in terms of the disclosures that go along with this. They have not legislated the model framework that has been put forward by the industry. And so to say that we in Pennsylvania need to do something far different than any other jurisdiction that has looked at this, and frankly, in contradiction to what courts have said in terms of looking at this and saying how these instruments are classified, I think would be a mistake. That doesn't mean that the legislation should not be clarified, amended, et cetera. But I think the larger issue is that we can fit this instrument into the definitions and the structure of Act 6 and have the disclosures that go along with it. Finally, when it comes to what is the fundamental issue? Do anybody entering into this, will they understand what is going on moving forward? Like, are they going to understand what they return? It is possible to estimate this is the amount of money you are receiving. This is your home value at the time of closing of this. Assuming that there is some maximum cap, pick whichever value you want, this is what you will owe. That is very similar to the disclosures that exist in truth in lending under federal legislation and under Act 6. And so I feel very comfortable when we put forward this legislation, and I would again turn to the Department of Banking and the Office of Attorney General, who indicated, yes, this is what we would recommend in this regard with these instruments, as opposed to a completely separate framework. The other thing I would point out in the hearing, and I know I said this at the beginning, but I think it needs to be reiterated, I have grave concerns of the approach that was taken by the industry in providing testimony to this committee and through this committee to the General Assembly. To say that they did not solicit positive testimony is laughable. If we look at the email that I have provided to you, it is specifically saying we are looking for stories that say this is a product that did X. I do not want you to do anything that might affect this product. And in return, here is a $50 Amazon gift card. That is outrageous, and I think we should not ignore that. I'd also point out that the industry did not answer the question that Chair Conklin asked about the Urban Institute report. They said they provided the data, but when Chair Conklin specifically asked, did you solicit this report, they did not provide a direct answer. And I think that is telling in terms of whether the industry, in providing the data, provided some type of compensation to the Urban Institute in putting forward this report. I think the committee deserves an answer to that. So my hope from this hearing, and I thank all the witnesses, and especially my constituent, Wendy Gilch, who is an expert in this area, as well as all the other experts, and my co-sponsors on the legislation, that the committee in its wisdom will move forward expeditiously to make sure that we are not caught in the same situation as what happened with MV Realty and what has happened in other circumstances when we have not legislated on consumer protection and prohibitions against predatory lending practices. Thank you again.
Representative Twardzik.
I just want to thank the testifiers for coming in and letting us know more about this product, because again, up till I spoke with a good doctor, I didn't know these things existed, and keep doing the research. But I agree with some of the testifiers that it's such a new product that we don't know the harm that can happen, and we need to put brakes on it to make sure we protect those people in our state and our. So thank you very much.
Chairman Lawrence, would you like to offer some closing remarks?
Sure. Thank you, Madam Chair. Just a quick question before closing remarks. And I don't know, maybe Indira, maybe you can, or Representative, maybe you mentioned that the Department of Banking and the Attorney General's office were in support of this legislation.
So this is the sequence of events that happened. We had put forward that we wanted to put forward legislation on this topic, and we asked them, how should we go about doing this? Initially, the Department of Banking said, similar to what the industry said, we don't want to do anything that are not mortgages. And so we turned to the Office of Attorney General when it came to consumer protection, and they said, this is how we would approach it. And so we circled back with the Department of Banking, who said, yes, this is what we would agree to as well. And so whether they are still in officially a support position or not, I can only go by the correspondence that we have received, where they said, the Office of Attorney General said, this is how we would approach this. The Department of Banking said, we agree with that. That's how we ended up introducing the legislation.
So it sounds like you've had correspondence with them. And that there's been some positive conversations, but it doesn't sound like we have a letter from either that says Department of Banking or AG is in support of this bill.
I would agree that we do not have a letter that has been provided to the committee saying we support this legislation. I can only go by the fact that this is the statutory language that they provided with us and said they agreed to say this is what we would recommend that you introduce. The conclusions you draw from that can go from there.
Very good. Thank you, Representative, and appreciate all of the testifiers who came today to the hearing here. I think it was very informative. And again, I think it's something, as Representative Twardzik mentioned and others have mentioned, it's not something that's been discussed. I've been here for a little while now in the legislature. This is not a topic that I've seen come across my desk previously. I think really the question here at the end of the day is, if legislation is going to proceed, in what manner is it going to proceed? And, not to bring up my favorite topic, milk, right? But, we have a lot of laws on milk in this Commonwealth, which is something I love to talk about. But, when we're regulating milk, the term milk is defined, right? So is chocolate milk milk? Well, it doesn't matter what I think. It doesn't matter what anybody thinks. It matters what the law says. And it turns out in Pennsylvania, chocolate milk is milk. But milk that comes in a can is not. And why is that? Because that's what the law says. So we need to determine in our wisdom if this product fits into that definition of residential mortgage or doesn't it. Is it chocolate milk or is it milk in a can? One way or the other, we have to determine if it fits into this definition. If it does, then House Bill 2120 is workable. If it doesn't, then 2120 needs amendments to describe how it needs to be changed to fit into either this construct or a new construct has to be created specifically for this product. So again, I appreciate all the testifiers who are here today and appreciate the good work of the three representatives on this. And Madam Chair, appreciate you stepping in very ably to chair the hearing here. Thank you.
I appreciate you, Chairman Lawrence. Again, I want to thank the makers of this bill for making us aware about the existence of these plans. I also want to thank all the testifiers that came before us today. You know, while I appreciate having options as a consumer, I think ultimately we want to safeguard those options for our consumers so that in the long run, consumers are not taking major losses or increasing their debt and the amount of debt to be paid. So again, thank you to the makers, thank you to all the testifiers, and until next time, thank you all for being here. Meeting adjourned, or hearing adjourned.